Why? Because you have now, why was 54 at all there? 54 was put in there because it was a divide. Should we take minerals and put it in the union list? They said no. Even today, atomic minerals are still in this. So the ownership must remain with the states. The ownership remains with the states. And for the bulk of the ownership is with the state. Only few, in one or two states where the land reform laws were not brought, the ownership remains. That Jacob's case analyzes it very well. So we now created a very strange legal architecture, which is a complete departure from the general pattern of land law. We decoupled mineral rights from land. That's peculiar to us. That's why Murthy got it completely wrong. It says land includes mineral rights. No, you're saying that. India doesn't. And you can't use it as a measure. And that's a separate chapter I'll deal with. So when 35 Act, and by the time 35 Act came, well, I was checking, devolution rules didn't have something like tax on mineral rights. This came in 35. By 35, and Jacob analyzes this, when the British government started giving those zamindari rights, many times the British government excised out minerals. Why? Because war effort. They needed iron, copper, and most of all, they needed coal. Coal was the most precious at that time, in 30s, the most precious natural resource. So, in 35 itself, they gave it to the federal system, that if you make this law, then your taxing power must comport to any law on mineral development, must not dilute or conflict with the law relating to mineral development. And when we have an all-encompassing law of mineral development, and I'll quickly now, your Lordship has seen all the sections, give the headings of all the sections. When you have an all-encompassing law of mineral development, to allow a handful of states who have the resources to upset fiscal burdens by taxing those mineral rights clearly drives coach and four to the law on mineral development. Because we must always remember the old adage, the power to tax is the power to destroy. If you have the power to tax, you can tax as much as you need. It's not a quantitative restriction, it's a qualitative restriction. So, it is my case, and I have to make that good, that entry 54 and the declaration and the provisions of the MMDR as we find them have been held to displace, although in theory it is to the extent, but the way we analyze MMDR Act, there's nothing left for the states on the ground. They may in theory have something available, but if we analyze the provisions of what actually the MMDR occupies, nothing remains. Why? Because in my respectful submission, the MMDR defines the minerals to which it applies. The only thing left out is if some mineral is not in the MMDR, then you leave it in 23. It defines the rights that can be created in those minerals. The state as the owner has no choice. It can only act under the union legislation. It can only grant prospecting licenses and leases in Form K and nothing else. So it defines exhaustively the rights that can be created. It defines exhaustively the terms and conditions on which those rights can be created and subjected to. The state or any owner for that. But let's focus on whether the state is the owner. It cannot add one more condition or remove one condition. From the conditions added in the law and in the rules and in the forms, the state cannot say, but I want to protect myself and I add one more condition. It defines the fiscal exactions, and I'm deliberately using colorist language. I'm not using the word tax consciously, for the grant or creation of these mineral rights. What all can you recover? Surface rents, royalties, dead rents, spells it out in great detail. It lays down, and this is critical. The levy, section 9 says you shall pay. There's no choice. If I remove mineral, I shall pay. It's almost like read like a charging section in a taxing law. So it creates a complete mechanism for the levy, the collection, the recovery, and the penal sanction.
In a better manner.
Yes.
What we have understood is the only role state has to play is to enter into a lease deed. You execute a lease deed. You can't put any other conditions in that lease deed. Just assist us. According to you, this act is everything because it is for the development and regulation of the minerals which are being extracted and not so far as minerals by itself is concerned.
Yes, not mines.
Tell us one thing. Keep section 9 in mind.
Yes,
It provides for collection of royalty. If state has only to execute the lease deed and do nothing, who will collect the royalty? And if somebody has to collect the royalty, that amount will go to whom?
yes.
Can I just clarify on that, Milord? Because that's the root question, possibly, Milord, troubling everyone, that state
Therefore,
would not get anything.
was therefore understood like this, that the royalty is also to be collected by state government, but it has to be paid to the union?
No.
It goes to the state only. The only thing with that happens under this act is the fixation of
But
the amount.
why are we going into all other issues? Your argument seems to be
Yes.
that by virtue of subclause 3 of section 9, it is only the central government by notification amend the second schedule.
Correct.
Therefore, the pricing will be in accordance with the second
That's the heart of the matter.
Correct.
so as to enhance or to reduce the rate at which it shall be payable. Therefore, the argument could be state cannot recover anything by way of royalty other than the price fixed in the second schedule.
Yes, and there is a reason why there is a structure, as the learned counsel has pointed out. Lord, it is pointed out, and I will give facts and figures. Lord, every state has a different mineral resources. Some states are mineral rich, some are completely having no minerals. Lord, if it is left to the state government, there might be inequality or non-uniformity in the prices. The center also has to match the prices with the international pricing. And this exercise of of royalty fixation is undertaken, and I have a lot of reports I'll show.
That's very important.
In consultation with the state governments. Each state comes and say that we have this mineral, we have this problem, we need this revenue, so fix it like this. And whatever is fixed,
Mr.
I'm sorry.
Mr. Mehta, then it is whose case that the royalty which is being recovered by state is not in accordance with the second schedule?
No. I'm sorry. No, the point is different, my lord. May I continue my answer to my lord? I'm grateful to my friend for his intervention. Because this is the heart of the matter. It's not just royalty, there are one or two others, but royalty is 9 points. What am I endeavoring to show? I'm endeavoring to show that these are limitations on a taxing power of the state. The state acts not qua state, not qua owner. The state is acting as a delegate under parliamentary legislation, collecting the royalty and keeping and then taking the royalty. But that is also under a law made by Parliament. Parliament has stitched up, as the law stands today, pretty much the entire area of the operation of mineral rights, including the fiscal burden, and I'm deliberately using my colorist language, the fiscal burdens to be placed. And as my lord was pleased to point out 9.3, and the solicitor very helpfully intervened to say, there is a whole exercise done at the time of 9.3 to match competing interests. The interests of the state in resources, and by definition, interests of some of the states in resources. Not all the states have this resource.
And international pricing.
Mr. Salve, now just to go back, you had told us that when we broke a link, the MMDR defines 1, minerals to which it applies, 2, the rights that can be created in those minerals, 3, the terms and conditions on which those rights can be created and subjected to, 4, the fiscal exactions for the grant or creation of the mineral rights, and 5, the levy, collection, recovery, and penal sanctions.
Yes.
That concludes this part, or there's something more?
No,
that you have?
I was therefore responding to what my lord asked.
Apart from this 5?
No, these are the 5 points.
That's all. No,
Yes.
that's the
Because this is...
So we have not missed anything.
No.
So that concludes this enumeration.
This-
That's why I just wanted to make sure that we have not missed something.
But I will, if I had been in slightly better health, I would have given my lord a written piece of paper today.
That's all.
I've had
And many of these things, we develop as we sort of
Also,
have
my
a
lord,
dialogue.
I must say, the advantage of not having too much in writing is, as your lordships asked questions, a lot has changed in the last 2 days in the way I have formulated my thoughts. And these are last evening, today morning's thoughts. Because as your lordships ask questions, my lord, we also sharpen our focus. If I'm right, and I'll quickly give a list of the sections, because your lordships have read them in detail, so that the point is complete. But if I'm right on this, then I submit I have met the threshold of the entry of It's not a high threshold, I submit, of any limitations, not a specific targeted limitation on tax, of any limitations created by a law relating to mineral development. Because if it becomes incompatible, and my Lord Justice Pardiwala was pleased to ask, 9 says you shall collect, this is the rate at which you shall collect. You don't get to fix the rate. And the union also will fix the rate in consultation with you, but once in 3 years and not more than that. Now why? Because you have federalized this. My Lord, there are states which don't have mineral resources, but which may be close to a port. You want to manufacture heavy metals, you want to manufacture certain chemicals which are close to a port. You need minerals for that purpose. But you don't have those minerals. Now, if the state from where the minerals emanate upsets the fiscal apple cart by loading taxes, you are distorting the whole endeavor by Parliament to try and federalize the distribution, and I use distribution in the larger sense, of mineral resources amongst those who utilize it best.